Welcome to the Am I Mental podcast, the Doctors in Court edition. My name is Sabine Fonderson, a general practitioner. Oh, and did I mention I really love listening to Snapped on Spotify? This is the case of a general practitioner who got too friendly with a patient. If you like these podcasts and enjoy listening to actions or inactions doctors do that end up in court, go ahead and follow, subscribe, and give me a review. Each like gives me the boost and encouragement I love to get in order to keep on posting these stories. I base the majority of these stories from real court case findings in countries like the Netherlands and the UK. Let's get to case number 10. The plaintiff is a 91-year-old female and has been a patient of the defendant, a general practitioner, for many years. In 2015, the plaintiff's husband suffered from a terminal illness and the defendant was closely involved in his care. After the plaintiff's husband passed away, the general practitioner remained close to the plaintiff and their relationship developed into a friendship. In the summer of 2022, the defendant's home was broken into. The defendant suspected the plaintiff's daughter and that she was involved in his home being burglarized. Based on these suspicions, the general practitioner ended the friendship and the medical relationship with the plaintiff. The plaintiff is suing her GP for 3 things. Number 1, for breach of confidential information. Number 2, for ending the doctor-patient relationship without formal explanation. And number 3, for inappropriately declaring medical costs when the plaintiff was no longer registered with the general practitioner. The Regional Medical Council had initially ruled each complaint as ungrounded and found in favor of the defendant. However, the plaintiff appealed the ruling and the Higher Medical Council reviewed the case again and came up with a new ruling. During the proceeding, the plaintiff attended, but the general practitioner did not attend and was represented by his lawyer. The Higher Medical Council ruled in favor of the plaintiff for one of the 3 counts. Which one is that, do you think? And if you stick around, I will let you know, obviously, at the end of the podcast. And what do you think the ruling will be? First, let us look at the facts of this case. The plaintiff is a 91-year-old female who I will call Mrs. A moving forward. She is appealing a prior ruling in which the judges found in favor of the defendant, her ex-general practitioner, who I will call Dr. P moving forward. Dr. P offers supporting statements to counter the claim and is represented by his attorney during the appeal ruling. Mrs. A was a patient of Dr. P for many years, and since 2015, their relationship had developed from a doctor-patient relationship into a friendship outside the clinical setting. The relationship, according to Mrs. A, developed and flourished during the time her husband was terminally ill. Dr. P was involved in the care, and during that time, both Mrs. A and her husband experienced family problems with regards to their daughter. Mrs. A and her then-husband shared information with Dr. P, for instance, that their daughter was involved with criminals, and this involvement caused both Mrs. A and her husband a lot of stress and financial issues. And after Mrs. A's husband passed away from his terminal illness, Dr. P would visit Mrs. A every Friday after work, and Mrs. A would on several occasions pet sit for Dr. P's dog. Both parties had each other's set of house keys. And during these regular contacts between Mrs. A and Dr. P on Fridays after work, Mrs. A informed him about her situation and the troubles her daughter was causing. And sometimes during these visits, Dr. P would perform medical tasks such as prescribe medication, give Mrs. A the flu jab, or measure Mrs. A's blood pressure. The relationship continued for 7 years until the summer of 2022 when Dr. P's house was broken into. In the hours following the break-in, Dr. P's suspicions mounted and he accused Mrs. A's daughter and her criminal acquaintances for masterminding and committing the break-in. Dr. P's wife and daughter also called Mrs. A to express their accusations, telling Mrs. A that they were sure that Mrs. A's daughter had broken into their home and stolen some jewelry. According to Mrs. A, the fact that Dr. P's wife and daughter called her up to accuse her daughter of stealing means that he in fact shared personal information that she had told him about to his wife and others. She is therefore suing for breach of confidential information. In Mrs. A's letter to Dr. P in August 2022, she states, "It seems that personal information that I told you, things I went through 7 years ago, events that affected me both physically and mentally, you shared with your wife. The fact that your wife then went on and told her children, or whether you shared that directly with her kids, but now her children are putting me under pressure." Dr. P responded to her letter in 2022, in which he states he was not aware of sharing information pertaining to a personal situation with others. The contact he had between him and Mrs. A was on a personal level, during which personal information was shared about both families from both parties. These moments occurred after working hours, and he did not even have his doctor's bag with him during those visits and never declared these visits as medical costs with the insurance company. Dr. P further detailed in his appeal that both he and his partner would visit Mrs. A on some occasions as friends, and it is during that time that his wife and him became aware of Mrs. A's daughter and that she was in financial problems and that she was involved with criminals. With regards to the suit of the breach of confidential information, the judges ruled in favor of the plaintiff. Now, before we dive into why they ruled in favor of Mrs. A, let us look at what a breach of confidential information really means in the medical setting. According to a publication in the British Journal of General Practice by Zuleta in 2021, medical confidentiality has a long history and is a key tenet of professional codes of ethics, from the Hippocratic Oath, which is over 2,500 years old, to the current guidance for doctors' duties from professional bodies such as the General Medical Council and World Medical Association. Confidentiality is considered an essential element for gaining and sustaining trust between patients and doctors. Confidentiality should not be ignored, and at the heart of this, patients should decide who has the right to their data and information. So with that context set, let us get back to the judge's arguments. In order to make their ruling, they asked themselves whether Dr. P acted in a manner that was expected of him in his profession. And based on the information they received regarding the extended relationship between him and Mrs. A, the judges rely on the code of conduct as stipulated by the Dutch healthcare laws, in which a doctor should always be respectful towards their patients, and that Dr. P in this case should have set clearer boundaries in his role as a doctor to Mrs. A. An important key of professional conduct in setting boundaries is, amongst others, that doctors should principally not treat their friends. Even though Dr. P claimed to be able to separate his role as Mrs. A's GP and Mrs. A's friend, it seemed that boundaries was not clear to Mrs. A. And whilst Dr. P regrets not having set those boundaries clearer, it is up to the plaintiff to prove and substantiate her claim as to how and when Dr. P breached confidential information she gave to him. However, Dr. P did not deny sharing this information with his wife, and whilst he claimed that information was retrieved when he was visiting Mrs. A as a friend, the judges find in favor of the plaintiff that Dr. P did indeed share information she confided to him with his wife, and that this act indeed breached his duties to respect Mrs. A confidentiality. On the second count, Mrs. A is suing Dr. P for abruptly and one-sidedly ending the patient-doctor relationship. Now, Dr. P denies ending the relationship solely on his own and states he told Mrs. A he would continue to be her GP, although that was no longer his preference. In her letters to Dr. P, Mrs. A accused him of wrongfully terminating the patient-doctor relationship. In his response, Dr. P stated that he had only advised her on several occasions to register with another general practitioner. In a letter dated in June 2022, Dr. P wrote to the legal representative of Mrs. A the following: I advised her myself last week that she should get another GP. Of course, I can still be her GP until such time that she has found another GP or in the event that there is an emergency. However, I really think it would be the best thing for her to find another GP. In August 2022, Dr. P wrote once more, "It remains my advice that Mrs. A finds another GP." And the following month, it was clear that Mrs. A had found another GP since her legal representative had requested a transfer of her file to the new GP. The judges ruled against the plaintiff in the case of wrongfully ending the doctor-patient relationship. The judges see that whilst it seems that Mrs. A felt that Dr. P wanted to get rid of her as a patient, there is not enough evidence in the email correspondence between Dr. P and Mrs. A's legal representative to show that he ended the relationship. The judges read that he advised her. There was further no proof of wrongfully ending the patient-doctor relationship, and for this reason, the judges found in favor of the defendant. With regard to the final issue, Mrs. A is suing that Dr. P wrongfully declared medical expenses or costs he incurred for her when she was no longer in his care. According to Mrs. A, based on her statements from her insurance company, she noted that a fee had been deducted from her insurance deductible for a flu jab, which she did not receive from Dr. P. By November 2022, she was already registered with another GP. Dr. P explained and argued that insurance companies pay GPs a stipend every 3 months for consultations at the clinic and for home visits. Stipends are deposited at the GP to cover these costs and occur on the first day of every quarter. So it occurs the first day of January, April, July, and October of that year. Meaning Dr. P received the stipend in the third quarter because she was still registered with him at the time. The fact that the insurance company paid that stipend to Dr. P does not mean that he made any wrongful declarations. There is no data to prove that he in fact declared the flu jab, and based on the insurance company's statement, the judges realized it was actually not a statement of actual declarations, but a statement of processes made in the system. Based on the lack of evidence and given the way insurance claims are handled, the judges ruled in favor of the defendant. So, based on the facts regarding the claim of breach of confidentiality, the judges ruled in favor of the plaintiff and reprimanded the GP. Regarding the claim of wrongful termination of the doctor-patient relationship and wrongful declaration of a flu jab, the judges ruled in favor of the defendant. This is again a very interesting case. And if you've been a doctor for as long as I have, you will find yourself in situations where you generally can develop a friendship between a patient. However, the boundaries have to be clear, and I can totally see how blurred that line can get between doctors and patients. So what strikes me is that Dr. P befriended Mrs. A after her husband died, and that can happen. I mean, his motivations and intentions seemed to be good. And it came from a place of goodness, and probably he wanted to be supportive to a 90-plus-year-old lady who was a widow and a daughter that was causing her a bunch of headaches. And it lasted really well for 7 years, but then we fast forward 7 years later, and the unthinkable happens. I mean, Dr. P's home gets burglarized, and that line of trust is broken because he immediately suspects that his patient's daughter is the one who was involved. So what did I learn from this? Number one, never treat your friend and never turn your patient into your friend. A while back, a friend of mine asked me to get involved because her neighbor's son was ill. Now, you can already imagine how complicated this would have gotten. These are two people that I've never met before. I've never met the neighbor nor her son. I heard my friend, I listened to her, and when I asked her what it is that she wants me to do, well, she asked me to help her neighbor out. My response at the time was pretty clear. I told her, listen, tell your neighbor that her son is in great hands. He is going to be seen by the best experts in the field. There's nothing that I can do or add at this moment, but I'm always here to listen. What would you have said if you were a doctor put in a situation where you're asked to provide your expert opinion on a friend of a friend. So, this is the end of the case number 10. And for me, it's a milestone because I've done 10 cases of the Doctors in Court edition. I'm going to take a mini break and we'll return in March with more podcasts. Thank you so much for your support, and I'm wishing you a fantastic break ahead.